Welcome back. My name is Jason. I'm a volunteer with the Self-Represented Litigants Society, and today we are going to be discussing another statement of claim. Again, here in Ontario is where these circumstances took place, and this is the Superior Court of Justice in the Ottawa, Ontario region. Although, in contrast with the first lawsuit that we took a look at, the first set of pleadings that we took a look at, this is a class action lawsuit. If you don't know what a class action lawsuit is, it's essentially a group of plaintiffs that get together to sue one or more parties, and in that lawsuit, essentially those plaintiffs have very similar sets of circumstances, or it can be easily assumed that they have easy or very similar sets of circumstances. In the first lawsuit, we were examining and taking a look at the statement of claim belonging to Sammy, the Sammy Yatim file. That was the 18-year-old young man who was shot and killed on a Toronto streetcar in 2013. This is a completely different area in Ontario, and excuse me, it is a different time period. This is from 2016 that this was issued, although that doesn't mean that the set of circumstances is from 2016. Often what we see a lot of in class proceedings like this one, I'm not sure about this circumstances. I haven't read this statement of claim, but often what we see in class action lawsuits are damages having occurred sometime well before the lawsuit is actually filed. For instance, against the Catholic Church for abuses of children. That's an easy example of when a lawsuit of many plaintiffs come forward to sue one or more persons or bodies to try and wrong something that happened many years before, sometimes outside the prescribed limits in the as set forth in the Limitations Act, which typically is 2 years. So I'm really interested to get into this again when we're taking a look at this claim. This title page area, this is really a notice to the defendant. This is really giving some really basic information to help identify where this file is, what the file is, who the parties are in the file, and essentially a little preamble, which is kind of standard for all of these forms, which kind of set out some basic principles of fundamental justice, which are your right to defend yourself, your right to be heard, your right to, get reasonable service, reasonable notice for service prior to any kind of action happening. What we're talking about here is November 2016 as when this was filed in the court, although and we just have the one defendant. So the one defendant is a doctor, and that appears to be, a law firm. I'm not sure who Karen Hamway is, but I'm going to assume that that's the doctor's lawyer. Let's get into it, shall we? So again, we have this section number 2 here is the claim. This is where we're basically laying out for the court at the trial, this is what I'm asking for. These are the orders that I am asking for from the court. And we can see here we have two different three different plaintiffs. So Rebecca, Davina, and Daniel, all with the same last name. So Rebecca claims on her own behalf and on behalf of all members of her plaintiff class against the defendant general damages for pain and suffering and loss of enjoyment of life. Special damages in an amount yet to be determined for out-of-pocket costs, the particulars of which will be provided prior to trial. Standard lines here. Damages for loss of income, loss of competitive position in the employment market, and or other economic loss in the amounts yet to be determined. I'm going to assume that some kind of medical malpractice happened here. This person probably went to a doctor, and I have no idea. Let's move on. Damages for past and future care costs. So yeah, including any subrogated claim on behalf of OHIP. So this is saying when we are OHIP is the health provider here in Ontario, and I think if I don't know about this one. I don't know about D here. I'm assuming that any kind of out-of-pocket costs that OHIP didn't cover, medical expenses, that's what they're looking for reimbursement of. I'm not positive though. To the extent that Rebecca or any other member of her plaintiff class required child support, the loss of opportunity to pursue the defendant for child support under the Family Law Act. Again, we're seeing the Family Law Act appear here in a class action lawsuit. I am really confused. I'm really anxious to find out what the circumstances are of this lawsuit are, or the alleged accusations, I should say. An order that the defendant provide the plaintiff Rebecca Dixon and all members of her plaintiff class with a DNA sample for the purposes of determining whether or not the defendant is their biological father. The doctor is, he's a doctor, is apparently the father. I think this is like the fertility doctor type of thing, whereas the doctor was, I've heard a couple stories about this happening, but where the fertility doctor was pretending to implant not fetus but feti, maybe just some kind of tissue in the uterus, maybe sperm or otherwise, and maybe he did his own, maybe he faked everybody out, perhaps. Punitive damages, which is kind of common. It's kind of a standard ask. If somebody has done something wrong, especially someone who's in a position of authority like a doctor, I'm going to ask the court for punitive damages to punish that person. Prejudgment and post-judgment interest in accordance with the Courts of Justice Act. Prejudgment would be from the time that I started this lawsuit until the time that the judgment was decided, and then post-judgment interest is an interest rate that is affixed to any costs after the judgment is issued, and that's set out in statute as to what that interest rate can be. Costs of this action on a substantial indemnity basis, which is it's a means of punishing it's a means of punishing someone for acting badly, and costs would be trying to get reimbursement for the full amount of their legal costs. Their full amount of legal costs, for instance, if it came to $100,000, they would be asking the court for $100,000 for just for their legal bills. And so partial indemnity basis, an order of costs for on partial indemnity basis would be, for instance, a percentage of maybe half or 3/4 or 1/4 of the cost bill to be paid by the loser, which is, what they're hoping to be the defendant in this case. Such further and other relief as this honorable court may deem just. This is, again, a catch-all line here. If I want to add on something at the last minute, this is my catch-all line here that kind of makes it okay that I am asking for additional relief from the court outside of what I've asked for. In class action lawsuits like this, costs on a substantial indemnity basis, if the law firm is charging $100,000 to their clients for going ahead with this lawsuit, they're also most likely doing this on what's referred to as contingency. And they also may be getting, 30% or more of the award after the award has been given. You'll see these big figures in class action lawsuits, like $200 million for class action participants to be spread out amongst all the plaintiffs or all the potential plaintiffs. If you're in this category, if you fit into one of the categories that are prescribed in the lawsuit, then you can apply to get a piece of that. So Davina Dixon claims on her own behalf, on behalf of all members of her class, general damages, same thing as in paragraph 1. So what's different here is an order for the defendant to preserve any and all records in relation to Davina Dixon and members of her plaintiff class. Punitive and aggravated damages. She's asking for aggravated damages in addition to punitive damages, which are different. I'll let you go and research what the difference between punitive and aggravated damages are, but there is a distinction. Again, pre- and post-judgment interest, cost of this action, and again, that catch-all statement. And then the last claim that's being made is made by Daniel Dixon. Again, same last name, pain and suffering, out-of-pocket, damages, competitive position in the employment market, damages for past and future care costs. So what I think these are referring to is any kind of costs in the future. If this is a child, for instance, and I don't know that it is, if it is a child, then these healthcare costs and any kind of loss of income in the future related to, I can't even imagine what the loss of income would be from, but let's move on. Let's see what they have to say in the rest of the. So this is different from, in contrast from the previous lawsuit we took a look at. The party section was after the introduction section. Again, the headings and how you tell your story here is, it's irrelevant in which order they're in. They should go in some kind of logical order, and typically I see parties listed right after the claim. But in our previous lawsuit, the Sammy Yatim file, the parties were listed after the introduction section or the background section. So again, The lawyer really controls this. If you're drafting up a document like this, or if you've been served with a document like this is something that, is interchangeable as far as the sections that will follow, or the subcategories or the subheadings that will follow. As we can see here, City of Ottawa resident, born June 1990, makes her in her 30s, maybe? Presently 26. Okay, at the time, she was 26. Rebecca brings this action pursuant to the Class Proceedings Act on behalf of the following class. All persons who were conceived at the Broadview fertility clinic with the wrong biological material, i.e., with biological material other than the material selected by their or chosen by their parents for the purposes of artificial insemination. Wow. So this doctor is being accused of artificially inseminating women with material or biological material, sperm or otherwise, feti that are not what was selected. Davina, all patients. So in this class right here, this is Rebecca. This is class of individual that is a person who was conceived. All persons who were conceived. So that's who that class of person is. And that's, that most likely represents the circumstances of this person right here. Davina is an individual who resides in Ottawa at all material times. Davina was married to the plaintiff Daniel and is the mother of Rebecca. Okay, so is the mother of Rebecca. So this happened some time ago, because she's presently 26 in this lawsuit, but they would have been looking to conceive well before that. So 1990 she was born. In 1989 or earlier is when this doctor would have had experience with these individuals. So Davina is the mother of Rebecca and brings this pursuant to the Class Proceedings Act. All patients of Dr. Barwin, so this is her class. All patients of Dr. Barwin who were inseminated at the Broadview fertility clinic with the wrong biological material, with sperm other than the sperm they consented to being used by Dr. Barwin for the purposes of artificial insemination. The plaintiff Daniel is an individual who resides in the city of Ottawa, married to Davina. Daniel brings this action pursuant to the Class Proceedings Act, and he brings this pursuant to all patients of Dr. Barwin who were not inseminated by way of artificial insemination, but became parent to a child conceived with the assistance of Dr. Barwin and whose DNA does not match the DNA of the child's intended sperm donor, and or who provided their sperm to Dr. Barwin to be used for artificial insemination pursuant to their instructions, and it was not used, and or who provided their sperm to Dr. Barwin for safekeeping, preservation, and it was not. Wow. That is a handful right here. So now let's go back up and take a look at what they're claiming now, and this will make a little bit more sense. So Rebecca, this is the child. This child is essentially claiming damages for loss of income. So I'm kind of curious to know what kind of damages this plaintiff has suffered regarding her income, finding out years down the road perhaps that her biological father might not be her biological father. Maybe she suffered emotionally speaking. Maybe. This is a hard one here. I don't know that I can agree with this. I don't know how the court assesses something like that. When we're taking a look at someone's general damages, one of the factors that can be used by the court to assess damages is their earning potential. And I don't know how finding out that your parents or your father or one of your parents are not your biological parent, I don't know how that affects your ability to have an earning potential. I can't understand that, but I guess that would be, again, broad strokes here is what most lawyers are going after. For the most part, we keep it as broad as possible, and during the course of the lawsuit, we narrow in on particular issues that are the most strongest for our case. Sometimes we may amend a claim. Again, these are referred to as this document and the statement of defense and the reply are all referred to as pleadings. And these pleadings, once they're filed, once they're served, once they're in the court, then another stage of the family or the civil matter happens, which is referred to as discovery. So once discovery happens, then really the doctor gets cross-examined by each of the parties. All the parties will be cross-examined by the lawyers for the doctor. The doctor's not going to just bend over and say, okay, I'm going to just pay you how much money. They're not even asking for money. They're not even asking for a dollar figure here. They're asking the court to determine that, which is kind of rare, although it keeps it more open-ended, and it has, in my view, a better possibility of, a better, probability of success, because I'm not asking for the $85 million. If I'm asking for $85 million and don't receive it, if that's listed here, then I'm considered the loser. And my lawyer, and I would be liable for the other side's legal fees, to some degree, depending on the amount of loss. It's hard to judge partial loss when it comes to, we're not taking a look at what legal costs would be owing to the other side, because what really needs to happen in that circumstance is the court needs to decide who's liable. And for instance, if the statement of defense points the finger at someone else, if the statement of defense all of a sudden says, oh, I'm cross-claiming against, or I'm third-party claiming against my nurse, this is the doctor's perspective. If I'm cross-claiming against the nurse who was my assistant for 15 years, I am cross-claiming against her because she was responsible for putting the sperm inside and she mixed up everything, right? If that's what the doctor's actually going to say, I don't know what the doctor's actually going to say. I'm saying that as a hypothetical, but if I'm in the position of the defense attorney, that's what I'm thinking about. I'm thinking about who can I now point the finger at to, reasonably try and minimize the liability here for me and my client. Moving on, those are the plaintiffs here. Here is the defendant. Dr. Barwin was a duly qualified medical practitioner who represented himself to the plaintiffs as a specialist in infertility. At all material times, Dr. Barwin was the director and owner of the Broadview Fertility Clinic and was vicariously liable for the conduct, representations, omissions, and/or negligence of the clinic's employees, agents, servants, and contractors. Again, this is the party section. Again, very familiar. Now we're getting into the background. Davina and Daniel went to become parents, but wanted to become parents, but were unable to conceive a child. In and around 1989, Davina and Daniel contracted with Dr. Barwin and the clinic for the purposes of assisting them in conceiving a child together. Before starting fertility treatments, Dr. Barwin collected and stored samples of Daniel's sperm at his clinic. Who wants to have that job? That's a fun job. During her fertility treatments, Davina believed, and Dr. Barwin represented to her, that he was inseminating her with her husband's biological material, that is, sperm belonging to Daniel. At all material times, Daniel and Davina intended that Daniel's sperm, and only Daniel's sperm, would be used to inseminate Davina. Davina and Daniel returned to Dr. Barwin's clinic on a number of occasions in 1989 for insemination attempts. Before each attempt, Dr. Barwin would show Daniel and Davina the straw. The straw? What's a straw? This is probably a technical item, but yeah, okay. So Daniel's sperm, which was labeled with Daniel's. Okay, Daniel's sperm had a label on it saying Daniel's name, and what they're alleging is in that straw, or probably a vial or of some sort, Dr. Barwin's boys were living. As a result of the artificial insemination procedures, Davina became pregnant in or around the fall of 1989. She gave birth to Rebecca on June 1st, 1990. From the time of Rebecca's birth into her childhood, teenage years, young adult years, Rebecca, Daniel, and Davina believed that Rebecca was Daniel's biological father, or believed Rebecca was Daniel's biological daughter. I'm kind of interested to know. How they came about to realize that it wasn't. All of a sudden, 26 years later, how are you now just suspecting then? That to me doesn't make sense. But it was not until 2016 when the plaintiffs began to worry that there may have been a mix-up in Dr. Barwin's clinic. In or around February 2016, Davina saw a Facebook post that stated words to the effect that it was unusual for two individuals with blue eyes to give birth to a child with brown eyes. Wow. This was started as a result of questioning eye color. She was concerned because she and Daniel have blue eyes and Rebecca has brown eyes. Wow. Davina assumed the Facebook post could not be true, but nonetheless booked an appointment with her family doctor in hopes that he would reassure her that the Facebook post was a myth. Rather than allay Davina's fears, her family doctor suggested that the family perform a DNA test as between Rebecca and Daniel. Alternatively, he suggested that they test Rebecca's blood type against Daniel's blood type. The plaintiffs proceeded with testing Rebecca's blood type. She tested O positive. Daniel has type AB blood. From available medical and other research, the plaintiffs learned that it was impossible for an individual with AB blood to conceive a child with type O blood. By way of paternity DNA test dated April 15th, 2016, the plaintiffs confirmed that Daniel could not be the biological father.
You are not the father.
The probability of his paternity was 0.0%. Oh my gosh. After discovering that Daniel was not Rebecca's biological father, the plaintiffs researched. I think we've kind of skipped over the introduction here. Yeah, we're past the background here. After discovering that Daniel was not Rebecca's biological father, so what we've done here is we've gone from this background heading and we've moved right into the facts. And that is this is the distinction mark here of the subheading here, which is kind of italicized. When we're taking a look at this, it's here for informational purposes. It doesn't really serve a purpose other than to draw a distinction between different parts of a story. Some people might say that it's not necessary, although then if we kind of go back up here, does the rest of these facts do the rest of these facts kind of fall under background information? Probably not. So that's why there's this heading here, I guess. After discovering that Daniel was not Rebecca's biological father, the plaintiffs researched the media coverage regarding prior legal proceedings that had been commenced against Dr. Barwin. They could not help but notice that Rebecca bore an uncanny physical resemblance to Dr. Barwin. Wow. In or around May 2016, Rebecca submitted a sample of her DNA to the ancestry website known as 23andMe. Through this website, she learned that her largest ancestry composition was Jewish, in the range of almost 60%. Dr. Barwin is a well-known member of the Jewish community in Ottawa. Wow. So, what's going on here is they're making this accusation that Dr. Barwin essentially substituted his sperm, that he's a member of the Jewish community. They haven't matched, I believe they haven't matched his DNA to the child in 1989. If it's true that Dr. Barwin was doing this, if it's true, would he have ever contemplated that a home DNA test could have been used 25 years in the future to determine that the DNA from someone that he oversaw the conception of was not, I think it's unfathomable at that point. I can't imagine, the different technology that was being used in 1989 compared to today. Wow, it's blowing my mind right now. In September 2016, Rebecca connected over the internet with a woman named Catherine Palmer, Kat, who lives in Vancouver and who Rebecca learned is a biological child of Dr. Barwin. Kat was born on January 31st, 1991, and is presently 25. Like Rebecca, she was conceived at Dr. Barwin's clinic in Ottawa. Her parents, Lion, who names their child Lion? Lion and Janet Palmer saw Dr. Barwin for his help in conceiving a child in or around the beginning of 1990 due to fertility problems. Lion, maybe because his name is Lion. That's probably why. Lion and Janet decided to proceed with artificial insemination by way of anonymous sperm donor. They specifically selected an anonymous sperm donor with certain traits and characteristics that were important to them. With Dr. Barwin's assistance, Janet became pregnant in 1990, gave birth in 1991. At all material times, Dr. Barwin represented to Lion that he was using the anonymous sperm selected by Janet and Lion for the purposes of inseminating Janet. Why would you want... I guess that's the way to go about doing it, is anonymous sperm, as opposed to having someone selected. In around 2015, Kat became curious about her genetic background in hopes of finding her half-siblings and perhaps even locating her sperm donor. Kat submitted, again, her DNA to the ancestry website Family Tree DNA. Through this company, Kat was matched with a second cousin who lived in New York City. Kat was immediately in touch with this match, and in tracing the cousin's family history, she determined that his cousin was a relative of Dr. Barwin. Wow. In August 2015, Kat contacted Dr. Barwin. This is a lot of hearsay right now, because we have a third party who's not a party who's making a statement. Although, most likely, Kat now is part of the class action lawsuit. So most likely she's joined the lawsuit as a participant under the plaintiff's section, she's called a member of a plaintiff's class. She discovers she's somewhat related to Dr. Barwin. And then, so again, these are all accusations. Allegations that have most likely yet to be proven in court. Kat and Rebecca underwent DNA testing. On October 2016, the DNA results concluded they were half-sisters. Wow. By way of the same biological father. Duties owed to the plaintiffs by the defendant. So we are skipping right into the liabilities section. So we are at page 9 of 19 right here. And we are now talking about the duties owed to the plaintiffs by the defendant. There's sufficient proximity. So right here, we're basically making loose accusations. We're not actually saying that Dr. Barwin is the father. Actually, above, it says that Dr. Barwin, that under Daniel's claim here. So, who provided sperm to Dr. Barwin, used for insemination pursuant to their instructions, and it was not used, and or. So again, we're pleading in the alternative a little bit here. And it is totally legal, and the rules of civil procedure allow for plaintiffs or even defendants to be pleading in the alternative, to be raising an alternate theory that is grounded in some sort of reality. So it can't be a far off, can't be an unreasonable theory. It can't be like a spaceship came down and zapped sperm into one of the girls. That's an unreasonable theory and cannot be, pleaded successfully. We're talking about the liability of Dr. Barwin to the plaintiffs and to the class of plaintiffs. They don't know, they likely don't know how many people are out there. So then the law firm, after they serve the doctor, then they go into the media and they say, hey, we started this lawsuit. Dr. Barwin is accused of essentially not using the genetic material that we gave him or that we told him to use. And he may have used his own. So they're saying breach of contract. In the previous lawsuit, we saw the actual causes of action listed in the claims section. So up here, we're not seeing this. We're not seeing, negligence listed in here, and that's completely fine. What is necessary, though, is to list what those causes of action are. And this is what we're doing here. This is essentially what the Yatim lawsuit does initially in the claim section. We're bypassing that and essentially just outlining it all together down here starting at page 9. Breach of contract is one of the issues that they take issue with. They're saying that they gave sperm to him, that their contract was essentially for, delivering my sperm into my wife. And if you don't do that, you're essentially breaching contract. What could be in here is, I was going to say battery. If you do something to someone and they're unaware of it or they're aware of it, like assault, essentially, when it comes to someone's person, battery can come into play. Davina and members of her plaintiff class consented to the insemination procedure on the basis that Dr. Barwin would be using sperm they selected under their contract with Dr. Barwin. What we heard was that an anonymous, what we've seen with Kat, this young woman from British Columbia, we have seen that Kat was a result of anonymous sperm donor. I don't know what the law says on, if that anonymous sperm donor can or cannot be a doctor that's treating you. I would assume that the legal or that the medical profession would have an issue with that. But legally speaking, I don't know. I would think that this guy has lost his license already just based on these accusations, his medical license. But who knows? So negligence, again, if you're doing something, there's a test for negligence. There's a test for battery. There's a test for whether or not I breached contract. If there's a breach of contract, there's specific elements that have to be present. I invite you to go to a Wikipedia page to figure out what those elements are for each of these causes of action. They're saying breach of contract, but I don't know that, what I haven't seen yet is that they have a written contract saying this particular thing. And that doesn't mean that they don't have a contract. What forms a contract essentially is consideration and a couple other elements. And, if both parties enter into an agreement, even if it's oral, if it's an oral agreement, that's still a contract. What we need to keep in mind is the provability of those circumstances. And how does one prove an oral contract 26 years later or some years later in the future if they don't have a paper copy of, this is what our roles and responsibilities were at that particular time? It can be implied, absolutely, because of this doctor's role. The doctor has a certain set of authority over the patients that he's overseeing, so he has to conduct himself in a certain way. Obviously, the medical profession has policies about this kind of stuff. I would say that if this is true, this goes against every single policy regarding, ethical behavior when in relation to the treatment of your patients. If it's true, no matter what, we're not talking, we're not here to really make commentary on this case in particular. We're just taking a look at how the lawyers have put these lawsuits together in their pleadings, in this statement of claim. And again, it's a treat to be looking at a statement of claim that is a class action lawsuit, which is sort of exciting because it's not really something in my mind that gets a lot of attention outside of, talking about big media award, when the media reports on the attention that a big lawsuit like a $200 million class action lawsuit brings. That's what we hear usually about class action lawsuits. We don't really get, I've never read a statement of claim that was a class action lawsuit before, or that was approved as a class action lawsuit. Further, in the alternative, so again, they're pleading in the alternative, which is completely kosher when it comes to the rules. The rules of civil procedure allow pleadings to plead alternatively, but it has to be grounded in some sort of reasonable reality here. Misrepresentation, infliction of mental suffering. So they're trying to say here that as a result of his actions, he intentionally inflicted mental suffering, or he was careless or negligent as to that effect. Breach of trust and fiduciary duty. This is a big one here, especially in the medical community. It's very, very hard to sue a doctor in Canada. The medical profession, has a lot of, they have the lawyers that will stand up for their doctors, but just to be able to pinpoint damages on a doctor, it's very hard to do that, presumably. So I've heard from lawyers. And primarily that's because the trust and care that we put into the medical profession, there is a certain amount of risk that I take when I go and see a medical professional. In a circumstance like this kind of just blows that away. This is just completely unheard of. Although I've heard of a case like this before in the US, I actually saw a documentary about something like this before, and this rings true. I mean, I remember an X-Files episode about something similar to this. So, I mean, this has been, this is This is very fascinating. So damages, next section here. As a result, again, we kind of have gone from the liability section to damages. How have the plaintiffs suffered? What have they gone through to try and make themselves whole again? Well, they did out-of-pocket expenses for DNA testing. They had a contract, and the doctor had a fiduciary duty, and as a result, they should be awarded general damages for pain, suffering, and loss of enjoyment of life. I don't know what has changed, though. If I'm the defense, I'm kind of hopping on this now. Like, what has really changed? Devil's advocate says that if I'm the defendant and I'm being accused of inseminating, women with my own sperm against their knowledge, yes, that's wrong and bad, and he should be scorned and lost his medical license and blah blah blah. But when we're really talking about it, when we're really thinking about it, these people lived 26 years without knowing this, and suddenly, they have loss of enjoyment of life now that they've learned this. I don't know that I buy that, and I don't know that a jury fully buys that part of this argument here if it's being made at trial. No matter what, though, I mean, it's pretty egregious to be thinking about, this doctor, if it's true, if this doctor actually inseminated these women with his own sperm, and he was kind of, wanting to spread his seed across the country or whatever. It's definitely weird, creepy. I don't know that I fully grasp, though, the damages to pain and suffering, though, and the loss of enjoyment of life. Because it's not like they were in a car accident, which is pretty easy to understand how someone has a loss of enjoyment of life after a car accident, especially if they have some kind of permanent injury. This, on the other hand, I don't know how there's permanent injury from this, even emotional. I mean, eventually they just, have to get over it. I don't know how money, brings them into a whole place. Yes, punitive damages for sure. I for sure see that as, like, if this is a successful case, I definitely see punitive damages being awarded here. Reckless and wanton conduct, including the cavalier use of his own sperm in insemination procedures, demonstrated by a reprehensible disregard for the health and safety and rights of plaintiffs, the members of the plaintiffs' classes, and of the general public, thus warranting an award of punitive damages. I see that here, but I'm kind of having a hard time grasping this one here. At 57. If you have thoughts about this, put them in the comment section below. This is a fascinating case. This is 2016. This is only 3 years old. Most likely, this is still in the court system right now. I would think that that's, not even close to being resolved right now. We have the last section of this pleading, this statement of claim. The last section of pretty much any document filed in Superior Court is going to be the back page and the back sheet. The back sheet is going to have the lawyers for the plaintiff's information. It's going to have the name of the courtroom, the title of the proceeding, the document. This is the name of the document. The name of the document will go right here. And over here on the left side, it's blank, primarily because this is where the court or the judge would make some endorsements over here. If any endorsements were going to be made on this particular document, this is where it's going to be made. I think that's about it for this case. If you have any questions or comments, please put them in the description box or put them in the comment section below. And if you're in need of support, if you're representing yourself, if you're thinking about representing yourself, if you're thinking about drafting your own pleadings, if you need support, if you've been served with a document like this, then you need support. And if you can't afford a lawyer, our organization is a nonprofit agency. We are 100% volunteers, and we help people all the time who represent themselves in legal matters. That was the purpose of this, to take a look at pleadings in general. We took a look at 2 different sets of pleadings, and I hope that you received something valuable out of this.